Yeah.
Okay. All right. So anything else, Jeff, or can I dive in here?
Now you can, Robert and those manager, everybody needs to fill in the evaluation at the end. This way we have dual proof and we can make sure that the CAM credit, CAM license numbers are entered properly, email addresses are entered properly. So it's just a second layer of help to get you all what you need. Emily, back to you.
All right. So this is our little title page. As I said, jumping into the present, updating your governing documents. To give you a little history also on us, on the firm, K. Bender Rembaum, all we do is association work. That's everything. That is for HOAs, that's for condos, that's for co-ops. That involves obviously this topic, redoing your documents for you or preparing amendments or helping you interpret your governing documents. But it's also everything else your association might need. We do collections work. We help you with your elections, everything essentially under the sun, reviewing contracts, helping you with your vendors if you need it. We kind of run the gamut when it comes to associations. We have a number of locations. We're 22 attorneys now, I think, 21 or 22. I'm bad remembering that number. Our main office is down in Pompano Beach in Broward County. We have an office up in Palm Beach Gardens, and then an office in Tampa, and an office in Orlando or in the Orlando area. And then in Miami, we can be available through appointments. So slowly but surely, we're trying to kind of take over Florida. I like to joke, but that's us. I've been here now 14 years. I've been practicing 20 years, I believe. His last year was 20 years, which is scary to think about how time flies. But here we are. So that's my little intro, but let's dive in. All right. So there's my little bio if you're interested. Okay. So let's start. Let's start with the basics. So today we're talking about amending your governing documents. Let's start very simply. What does that mean? What are your governing documents? What am I talking about when I say that? Your governing documents essentially are a number of different documents, right? There's a hierarchy involved. If there's ever a conflict between the documents, you follow that hierarchy. Your declaration, and for condos, that's your declaration of condominium. Typically, that's what it's called. That's top. All right. That's number one. That's sort of, we joke that that's your constitution. That's your guiding light. That's what you're going to follow for most everything that we're going to talk about. That should contain all of your restrictions. That should have your lien rights in there. That should be what it outlines if you're 55 and over, if you have ARC provisions, if you have sale lease approval rights. All of those things should be spelled out, should be in your declaration. For condominiums, that's the declaration of condominium. For an HOA, it's your declaration of covenants and restrictions, or easements and covenants and restrictions, or covenants and easements, or just declaration of restrictions. The HOAs tend to get a little more creative with their titles there. Sometimes you'll hear attorneys just call them the CCRs. But essentially, that's all the same thing. So we're talking about your declaration. So if you hear me kind of shorthand, just say declaration today, whether we're talking about condos or HOAs, that's what I'm talking about. Your declaration of condominium or your declaration of covenants. Next item in the list is your articles of incorporation. Your articles of incorporation are the document, that's the document that sort of sets you up as a corporation with the state of Florida. So hopefully you're aware that you are also a not-for-profit corporation. When you're on a board, you're part of running a business, essentially. This is what's laid out in your articles of incorporation. That's what's filed with the state. When you go to sunbiz.org, that's what was filed there to get you a presence there. Typically, that lays out maybe, how many directors you're going to have, or maybe when your annual meeting is going to be, or something like that. Your bylaws, sort of similar, right? So your bylaws are going to have, again, all of those kind of operational things in terms of the governance of your community. So again, how many directors you might have, when your meetings are going to be, what the notice requirements are, if there are any requirements for the directors, do they have to be members? What does that mean? Those types of things. That's typically outlined in your bylaws. So we joke, because we talk about this hierarchy, your declaration, your articles, your bylaws, we joke that from that apparently old ad back in the day, a little dab will do you. That's the cheat code for you. That's how you can remember that. So DAB, declaration, articles, bylaws. Occasionally, there will be sort of a discrepancy maybe between your articles and your bylaws, and in that case, the articles would control. Last, but sort of least, actually, your rules, right? So your rules, you may have rules that were established by the developer early on. Maybe they're attached even to your bylaws. Maybe they're recorded, but maybe not. Maybe these are rules and regulations that the board has adopted through the years. Those tend to still be important, obviously. They are typically sort of your day-to-day restrictions and things that help guide your owners and your residents, but they don't have the same level of importance and enforceability as a restriction that would be in your declaration. And we'll get into that a little bit later on. But if they're in the original recorded version, then they are given a little bit more, again, importance. If they were just adopted by the board, not adopted by the membership or not approved by your membership, that's why they may be sort of on a different level when we're talking about enforceability. Any changes to your declaration going to involve a membership vote. It means your owners are all approving it. Your owners are getting involved. It's not just a board decision. Also important when we're talking about your governing documents is the interplay with the statutes, right? So your condominium associations, you guys are governed by Chapter 718 of Florida statutes. That's what you hear everybody call the Condo Act, Condominium Act. Now, Chapter 720 is what controls for HOAs. So not 718 if we're in HOA world. 720 controls for HOAs. That's not really typically called the Homeowners Act or Homeowners Association Act or whatever, but sometimes shorthand, we call it that because the Condo Act has its own name, so why not? But it's Chapter 720. For co-ops, and I know we did have at least one person here who's in co-op world, you guys are a little different. Co-ops sort of run similarly in terms of the statute. Your statute is very similar to 718. It's Chapter 719, but it's written in a similar fashion to condos, and most of what I'm going to say for condos today probably applies to you, but your documents are a little different. You don't have a declaration, you have a proprietary lease, you have bylaws, so it's a little different, but that's just something to be aware of if you're in co-op world, and I keep saying declaration, don't think I'm intentionally trying to leave you out here.
And Emily, I want to make sure I answered a question properly. There was a question posed about the education requirements for cooperative board members, and the way I answered it was that at this point in time, the only thing a cooperative board member needs education-wise is their version of a certification class. There are no CEU requirements at this time, correct?
Right, that's my understanding.
Okay, that's how I answered it.
They've not given you guys that extra requirement.
Okay, thank you.
Co-ops tend to get kind of lost in the shuffle a little bit. I know, I feel your pain, but it's almost easier if you guys are kind of left to your own devices. So, all right. So next slide, let's move on. Now, again, we're talking about amending your governing documents, right? So let's talk about the amendment process. The big thing you're going to hear me say today 1,000 times is you want to see what your amendment process is. Let's start there. It's not going to be the same across the board. It's going to be in your governing documents, most likely. There is a default if your declaration doesn't mention anything about how to actually amend it, but ultimately look to your governing documents first, and they could be different. You could have a different requirement for what you need to do to amend your declaration versus what you would need to do to amend your bylaws. On a rare occasion, sometimes because again, the bylaws tend to be about the meetings, about the board, about sort of the governing side of things. Occasionally, some bylaws, you don't need a membership vote. Maybe you only can do a board vote to change the size of the board or to require a different, different something. But your declaration, to amend your declaration, you're going to need a membership vote. If you are one of those communities that has never amended your governing documents, or maybe has never amended the portion of your governing documents that involves amendments, again, it gets tricky when we talk about amending the amendment portion. But if your threshold is very high, if you have one of those requirements where to amend your declaration, you need 75% of your owners to vote or 2/3 of your owners to vote, that's a lot. That's a high threshold. That's going to be very hard to achieve. Not necessarily because you're trying to do anything, all that controversial, but even if it's a very clear-cut, well-supported amendment that's, that almost everybody in the community would support, and there shouldn't be any sort of scandal or controversy about it. If you're one of those communities where you just have owners who don't really pay attention, who maybe there's some investors, maybe you have some snowbirds, it's very hard to get the participation, and you're not going to get 75% to approve something very easily. It's going to require a lot of effort on the board's part. If that's the case, if you have one of those higher thresholds, first step, before we get into the nitty gritty of what you might want to amend, first step is maybe amend that section. We can do amendments in different ways. You can talk to your counsel about doing sort of a complete overhaul, doing an amended, restated declaration, or if you want to do amendments sort of a la carte, as I like to say, and do different sections and things like that. But before you get into that, before you're spending, attorney time and hours of preparing this, reviewing your documents, all of that, before you incur those fees, because guys, I try and be practical with all my clients here. I'm going to be honest, before you spend all that money, and I love to do it for you, love to spend the time, doing your documents, but start with, what's our amendment threshold? Do we need a 75% vote? Do we need 2/3 vote? Can we reduce that down first? Can we get that to a number that everyone would be okay with? A majority of our ownership, or, of the membership, or even better, a majority of those present at a meeting at which quorum is obtained. That reduces the number even more. Now, again, maybe you have a community that would kind of get a little suspicious with that and would prefer just a straight majority. Okay, you guys know your community better. Talk to your counsel, see what your provision is. Big takeaway, look at your amendment threshold first and see if you need to amend that first. So that's my number one tip, and I'm going to say it probably 10 more times. Another thing to keep in mind when we talk about amendments, essentially there's a 5-year statute of limitations. So if you have some amendments that, maybe you weren't sure if they might be subject to challenge, someone might bring an issue with it. If it's already 5 years in the past, you're solid. They can't be challenged at this point. You want to look at, as part of this whole procedure, do you have to have a meeting to get that membership vote? Could you do it through a written approval process? Could you get consent forms from your owners? Could you do it through a mailing, or do you have to schedule a meeting? If we're scheduling a meeting, we're going to talk about obviously voting through proxies, using proxies for that vote. Proxies are good for the 90 days following the date for that meeting for which they were given. So you do have some time, a window of time to possibly come back, have a, part 2 of that meeting, reconvene the meeting. If you don't get enough votes the first time, if you don't get enough proxies the first time, continue the meeting, keep going. You have that 90-day window, gather more proxies, gather more proxies, gather more proxies, hopefully until you can get the number you need and you can vote, or you can pass that vote and get the end adopted. You want to send out a copy of your amendment once it's approved to your owners, make sure they're aware. Keep in mind, the amendment's not effective until it's recorded in the public records. So if you have your meeting, last night, and all of a sudden you've adopted new criteria about sales and leases and all of these other things, and you have a sale application or a lease application that's pending, and you say, oh, okay, well, we're going to apply these new rules because we adopted new restrictions last night, that amendment passed. Can't do that yet. It needs to be recorded before it's going to be effective. Need to disperse it to everybody. Some things to be aware of too. Some amendments are treated a little differently. You might have language in your governing documents about, terminating your condo. That's usually sort of a hot button topic. Oftentimes in just that section, even if your declaration separately has an amendment provision that says, amendments require 2/3 vote of our owners, your termination provision might read, to amend this article, it requires unanimous vote or something higher, or 75% vote of the owners. That could be too. So you want to make sure, again, you're very careful about these things. Leasing and rental restrictions. This is an important topic. Obviously, we get questions about leasing restrictions. How do we reduce our leases? We want to increase our property value, and we think tenants aren't so great for the community, and our community has all these rentals now, and it's sort of a runaway train, and we want to curb our renting. We hear all of those types of comments. If you were going to propose an amendment to try and cap leasing or reduce your leasing, or maybe put in a rental moratorium, you have to hold on to the property, own the property for 12 months before you can rent as a new owner, or 24 months as a new owner. Any of those types of restrictions, those are all valid, legitimate restrictions. You could put them in your declaration. You could do an amendment to reduce your leasing if you wanted. But certain things to consider, the statutes, both of them now, 718 and 720, have certain language in there about those amendments where essentially it creates almost a statutory grandfathering. If somebody owned prior to that amendment and doesn't vote in favor of it, it may not apply to them. There's some more detail there and some nuances there, but talk to your attorneys if that's something you're thinking about doing. It would apply to everyone who takes title after, and it would apply to everyone who voted in favor. But if you already have someone who maybe is a problem landlord or something, and that's the person you're really secretly trying to limit that person's rentals, you might be sort of spinning your wheels because then you may not be able to achieve that goal in this way. But talk to your attorneys and you can go through sort of the details of how that works. Suspension of voting rights, that's another consideration. If we're talking about taking a vote, talking to our owners, having our owners vote on something, do we suspend voting rights? Is that something we do regularly? That's going to impact your vote. Maybe that actually doesn't help you, because if you have delinquent owners, typically we've found they don't vote, they don't show up, they don't participate anyway. So if you're suspending their voting rights, now you've taken them out of the quorum requirement, and potentially you've kind of thrown your numbers and your percentages off a bit. If you kind of leave them in the mix and they're not going to vote anyway, maybe that's better, maybe that's worse, but that's, again, something you want to talk to your counsel about and make a business decision about. Mortgagee approval, that's another factor to consider. A lot of times your documents will say things like, if you're amending this section, it requires approval of mortgagees. If you're looking into anything having to do with foreclosure or assessments, that's where you may see some language like that. Sometimes it's a blanket comment. Sometimes it's any amendment requires mortgagee approval. That's rare, but it could be. The mortgagees, though, and it sounds like a daunting task. We need to get all of the lenders to agree to an amendment. That's crazy. Well, yes and no. Process, typically, there's something in the statute where there's essentially a written notice procedure, a negative notice procedure. You have to run title, you have to get the identities and the contact information for all the mortgagees that have mortgages in your community. But once you do that, they get a mailing. You send out a negative notice mailing, essentially, that says, here's the proposed amendment. And if we don't hear back from you, we presume that you've consented and you're approving. And there you go. So even though, again, that process sounds rather daunting, it's not as bad as it sounds. And ultimately, if you don't get mortgagee approval, this is where that 5-year statute of limitations comes in. If you don't get mortgagee approval, and it's an amendment that is unlikely to draw any attention of a lender anyway, then maybe you're sort of in the clear. It never comes up. You don't have a challenge. You're okay. 5 years has passed. Good to go. I don't know, but talk to your counsel and look into that. So lots of factors just on the amendment process, considerations, who it's going to apply to, who you need approval from, how many people, their percentage, the meeting requirements, all of these sort of technical, practical things before we even get into what we might want to change, which is why I know we have a lot of communities that tell me, well, we've never amended, or we had an amendment from 1982, and that's our last amendment. This is probably why, all of these hurdles. But again, counsel can help you kind of weed through some of this. All right, so let's get into some of the reasons of why you might want to amend. Let's start there. Now, all right, problem we have when people say we want to amend. A lot of people will say we want to amend because our governing documents are just outdated. They're super old. They were recorded again in 1972 or 1985 or whenever. Now, that could mean different things. It doesn't necessarily mean your governing documents are bad, But you might have language in there that you don't want to have in there anymore. You might have language that is maybe not so appropriate in today's day and age. Maybe the laws have changed. Maybe they're illegal. Maybe they're exposing you to some sort of liability risk. The bigger factor most of the time, what we hear from our clients is we're worried about money. We want to make sure we're recovering as much as we can possibly recover, especially if we're talking about foreclosures and collections and things like that. And again, collection seems to be kind of on the rise again. So why not be able to collect as much as you can? Make sure you can again, and we'll get into some of these details, that you're not sort of leaving money on the table, as they say. The other issue is when you have some of these old provisions that might be potentially discriminatory or somehow inappropriate in some other way, again, that risk and exposure to liability may ultimately cost you money, because if someone brings an action, now we're involving insurance defense or legal counsel, and we're paying fees to defend it. And potentially there's exposure where we might have to pay someone for the inappropriate language we have in our governing documents. So all of that, those are completely legitimate reasons to be thinking, hey, maybe we need to review our governing documents. Maybe we need to amend our governing documents, even though they've been in place for 40 years and so far so good. Now's probably a good time. All right, so let's go through some sort of hypotheticals and questions and all of that. And we used to do this in a little bit more of an interactive way where I would, ask the room to answer and then tell them if it was true or false. But we changed it since it's via Zoom. So now you get the answers already on the screen. A foreclosing lender, true or false, is required to pay 1% or 12 months of delinquent assessments. False. Now, we also wrote these in a way where it's a little bit misleading. The reason that sounds very familiar, a foreclosing lender is required to pay 1% or 12 months of delinquent assessments, is because the answer is probably, maybe. It's not a bad answer. 1% or 12 months probably kind of, sounds familiar to you guys. There's probably something in your brain going, wait a minute, I think that's right. 12 months, 1%. Wait a second, that's a familiar term. That is safe harbor. That's what you hear. The statute says the lender's going to be responsible for safe harbor, but that's in the statute. So, and that's for both 718, 720. There's language about safe harbor. A first mortgage holder who takes title after foreclosing their mortgage on a property, on a unit, is entitled to basically wipe out everything that is owed to the association. And the only thing they have to pay is the 1% or 12 months. Probably, not always. So there's a little asterisk right there. If your governing documents, so that's what the statute says. If your governing documents say something different, if your governing documents say, oh, if a first mortgage holder forecloses their lien or their mortgage and wipes out the association's lien, the association's interest is completely gone, a first mortgage holder may owe, don't let this come as a surprise to you guys, may owe the association nothing. So you could have Bank of America loan in your community. That owner stops paying. They stop paying the association. They stop paying their mortgage. Bank of America does a foreclosure. Association figures, great. Well, we won't do anything. We know we're owed money, but there's no point throwing, more money after this owner anyway, because the mortgage is going to foreclose. The lender's going to foreclose. We'll let that go and we'll see what happens as a result of the foreclosure. Bank of America may foreclose. Bank of America may take title. And the association's first instinct is to say, hey, Bank of America, you owe us the money now, right? All the money that was acquiring on that property, pay up. You guys have to pay it. Well, they may say, no, we actually owe you nothing. We'll start paying you going forward. Now that we've taken title, we'll pay you those assessments on an ongoing basis, but we owe you nothing for the back amounts because your governing documents say we don't owe anything. Or the maximum you could get is safe harbor. That would be the provision under the statute, but you have to see if your governing documents control over the statute. That's an easy amendment. That's something where we can just sort of change it to default back to the statute. And if the statute one day increases, that would be nice. That's an easy amendment, like I said, and typically you can get your owners sort of on board with that one because, again, it maximizes the recovery you guys are going to get as the association from a foreclosure. It's also important if you have a third party purchasing after that lender. If the Bank of America forecloses, but it's ABC Investors that takes title, you often get a discussion with them where ABC Investors may say, well, we foreclosed, but just like the bank, we foreclosed, so we get the same treatment as the bank. You want to make sure, again, well, wait a minute. ABC Investors is not the bank. So if the statute says the bank gets that 1% or 12 months, we could change our documents to say ABC Investors, you don't get that same privilege. We can say you owe us everything. That's a possibility as well. So there's a big swing here depending on how things work as the result of a foreclosure. You guys might recover all of your delinquent amounts, or you could recover none of your delinquent amounts, and you may only be getting, again, everything coming forward. Still a win if you obviously get rid of your sort of deadbeat owner, but let's maximize your recovery. Let's try and get you all the money you can. We don't want to leave money on the table, right? So that's an easy amendment. You sort of start there because that's one that most people can understand and most people can get behind. Then we get into some more sort of nuanced things here. So let's see, what about this one? Landscaped grass lawns must cover the bulk of the front yards in our HOA. Is that true or false? Well, and this is an HOA question, not a condo question so much, but 720 has a provision in there where it says that we cannot enforce governing documents that prevent an owner from installing Florida-friendly landscaping. That's the language. Statute protects Florida-friendly landscaping. So if you have a covenant in there or a restriction in your governing documents that says something like, 95% of the front yard has to be covered in grass, you might run into an issue if you have an owner that gives you an ARC application saying, oh, we don't want to pay for that. We want to get rid of the grass. We're going to cover it in, rocks and succulents and all of these other things. Well, your knee-jerk reaction may be, our covenants say we need 80% of the lawn or 90% of the lawn to be covered in grass so we can reject this application, right? Maybe, maybe not. You need to look at your governing documents. You need to check with the statute because you might actually have to allow, again, for Florida-friendly landscaping, and this might be one of those applications that is actually asking for Florida-friendly landscaping, but get with your counsel and see and make sure, because it doesn't necessarily mean you have to approve everything.
And Hugo had a question in the Q&A. I'm going to throw a word out there just because this stuff I know from one of the divisions I used to run. A word that is thrown around for the type of landscaping, xeriscape, okay, which starts with an X. And that's what Emily mentioned. It might be something that doesn't require a lot of maintenance, rocks, mulch, shrubbery, cactus, things that don't require a lot of water. And that was something that was very, very important back when I was on the field when we had severe drought situations, for example. So we updated our governing documents to allow stuff like that. So this is why a class like this is very, very important.
Right. And I think we're back sort of in drought world again. So it may be coming up again. And the thinking was, and it does sort of make sense. We think about it from the legislature's perspective. We always want to save water. We want to save energy, save those things. So if there is a way to do that, that's something they considered, and you may have to allow, and you may want to make sure your documents are clear that you're allowing that, you're complying with the statute. This is a sort of an interesting one. This is only an HOA question too. The board has sole decision-making power when it comes to filing lawsuits. Again, knee-jerk reaction is probably, yes, of course they do. The board has sole decision-making power, of course. Well, not quite. So again, another asterisk here. Section 720 does say that the declaration can't have a provision prohibiting the association from suing a developer. That's all well and good. So we're protecting the owners, we're protecting the association, saying the developer basically can't pull a fast one. They can't draft the governing documents to say, hey, you can't sue us when we're gone. That's nice. The statute does say that. So they can't do that. But there's a little sort of a compromise or caveat here that the statute does also say that the association can't commence litigation against a party where the amount in controversy is over $100,000 unless the members vote to approve that. So that would be something that's not just board vote alone. So if the board is thinking we need to file a lawsuit and the amount in controversy is over $100,000, they can't do that on their own. They need the members to approve that as well. it usually comes up in the context of suing the developer, because that's usually where these big ticket lawsuits come in. So that may be something that requires a membership vote. That might be something you want to double check again, make sure your governing documents sync up with that and make sense there. And we sort of touched on a key thing here. Your developer is who wrote your governing documents, right? They drafted them. They put them together, and let's be real, they put them together for themselves. They put them together to make the community sound good so they could sell, so that lenders would, to encourage lenders to loan into the community. They put certain protections in there for themselves. They weren't thinking about you guys as residents, as owners, actually living in the community and what that really means for you. They put some general restrictions, I'm sure, and things that maybe cover, kind of the key topics. But once you live in the community, you're going to see things differently. You're going to exist and sort of in living in the community differently than the developer viewed your community. So your governing documents, if they're the original set, there's a completely different perspective of how they were drafted. Once the community is active and you have owners, those owners probably want to have a say in what their governing documents really restrict, what they really say. This one, our next question here is the hot topic. And this is where, we see this comes up a lot for a lot of our communities. And this is something that we have a class just on guests and screening and sales and leasing. So I could talk about this for an hour, but we won't. So let's try all owners go through the screening process in our community. Yes or no? Well, maybe, again, depends on your community. And this is condos or HOAs. The authority to screen sales, the authority to screen tenants. And then what does that really mean when we say sales and leasing? Does that also include, what if there's a quitclaim deed that's executed? What if there's an inheritance? What if there's just a life estate and then the property transfers because that life tenant has passed? All of these other ways that property could be transferred, essentially, do your governing documents address those as well? Can you screen a potential new owner if they were the remainder man from a life estate? Can you screen that potential new owner if they inherited the property, if they were gifted the property, if they got it through a quitclaim deed? If it's the original owner, but they're putting it into, an LLC that they've created, but they're the same parties and they just signed a quitclaim deed and there's no sale there. All of these things are things that you'd have to look at in your governing documents. If you want the authority to review all of those transfers, that language has to be in your governing documents. It's not in the statute. So again, for condos, HOAs, co-ops, any of those transfers, if you want to be able to review those, if the board wants to be able to reject any of those, that authority needs to be in your governing documents. And again, you really want to make sure that the wording is right. Are you just reviewing sales and leases, or does that include every kind of transfer? And then maybe you want to draft it a little differently. Maybe we're okay not necessarily screening the whether or not this person can own it if they've inherited it, but we're only screening them to see if they could live in the community. Fine if they take title as, the grandson of whoever, but maybe when we run their, criminal history, they don't have the greatest history, and we're okay if they own, but we don't want them living in our community. Those are distinctions. Those are things that can be worked out in the language in your governing documents. So you want to look at that. And that's something we're hearing about a lot lately. The screening, the sales, the lease approval. Make sure your governing documents have the authority you want them to have, and that you guys can then enforce. If you want to be able to do that and the governing documents don't say you can, and you deny a sale or you deny a lease improperly, that exposes you to some potentially serious liability. If you have an owner whose sale you denied, but you weren't on a strong basis, you didn't have that strong foundation, you didn't have the documentary authority to review that sale, and you deny a sale and it falls through, and that owner can't sell their unit for 4 more months, and they had to take a hit on the sales price, that's some serious liability you've exposed the community to. They might come after you because now they lost $50,000 and 4 months of rent or whatever it was. So all things to consider. but all of that authority needs to come from your governing documents. All right, this is another hot topic, guys. I'm going to skip the first one. We'll circle back, but last one, or the second one here, is the residents are prohibited from having clotheslines in our HOA. This kind of syncs up. It makes a little bit more sense when you think about it in terms of that xeriscaping, the Florida friendly landscaping. It's in that same vein. We want to make sure that, again, we're conserving energy, renewable resources, all of that. So the statute says that essentially, again, the HOA can't enforce documents that prohibit energy devices based on renewable resources. So clotheslines count. You have to let owners have clotheslines if they want to. And solar panels, that's another big one. And solar panels, I can understand sometimes that's an issue. But again, there's language in the statute where communities will say, but solar panels are ugly. We don't want them in our community. Or maybe you're a townhome community, but you are an HOA, and maybe the association takes care of the roofs. And they say, well, wait a minute, I don't want him putting solar panels on our roofs. We take care of these roofs. Certain considerations there. Again, if you have a provision in your declaration, you may have to amend it, or you may have to at least be aware that you can't enforce it if there's a strict prohibition there.
Emily, can the docs say to try to make every effort to have it not visible from the street? Can it say stuff like that?
So this is the other thing. You can kind of tailor it a little bit. The statute does allow you to still have some say. We'll say it that way.
Okay.
You can require an application. You can require board approval. The board can have rules about the orientation of the solar panels. The problem is having a blanket policy if you can't see it from the street is an issue, because the statute provides that essentially the solar panels have to be able to work. They have to be able to face, and again, this is all science and all that fun stuff. They have to face a certain degree south. So if the only way that the solar panels can, essentially catch enough light is on the panel that faces the street, you may have to allow them to do it.
You may have to. I was thinking more along the lines of like clotheslines and stuff like that. That's kind of where
you can have provisions that you can sort of keep them in the backyard, that kind of thing. But right. So all of these things to kind of consider. Now, we'll circle back to the one on top here. Once the law changes, the change is automatically applicable to your community. True or false? False. And this one is a lot more complicated than it sounds, because we get this question all the time, and we almost started off really with this same issue. Which one controls our governing documents or the statute? And then if the statute changes, do we just get to follow the new statute? And that's a loaded question. And it's sort of the classic attorney answer that I can't say yes or no. I can just tell you it depends. And I'm sorry. I'm sorry in advance for saying that, because it sounds like a cop-out, but it's not. It really does depend. There's certain language that your governing documents may have. We call it Kaufman language. It's sort of the magic words, comes from an old case, but the magic words are basically, do your governing documents follow the statute, whether it's 718 or 720, as amended from time to time? Those are the magic words. If that provision is in your governing documents, probably in your declaration, again, it could be condominium or covenants, in your declaration, then your declaration does follow the statute as it changes from time to time. So that means if your declaration was drafted in the year 2000, statutes were different back then, but if that language is in there, your declaration gets to sort of change with the statute, and we don't have to amend every single time. Now, again, that's a little more complicated than that, because there are certain changes, and then if you don't have that language, there are still some things that the statute might control over, and it depends on if the change in the statute is something that's procedural or remedial in nature. If there's a substantive change, if you have, and it gets into this whole complicated legal discussion, but your declaration is a contract, essentially. And there's certain contract law in the Florida Constitution that you can't impede a contract right. So if your declaration has a certain substantive right in there, there's an argument that the statute changing can't impact that contract right. So again, for certain things, and we won't get into all the possible nitty-gritty here, but if it's a procedural change to the statute, then it is going to impact you, and it doesn't matter if your declaration changes or not, doesn't matter if the declaration has that language. Easiest example for that is how the condo elections work. There is a very clear procedure. Your documents are sort of put aside. 718 and the Florida Administrative Code spells out how condos do their elections with 2 notices, 60 days, 40 days for the notice of intent, a 14-day notice with the ballots and the envelopes and all of that. All of that is a procedure. That is all spelled out in the statute. That is all spelled out in the admin code. And everyone who's in the condo world is very familiar. That's how you guys do your election, because that's the procedure in the statute. And it doesn't matter what your bylaws or governing documents say if they required a different notice procedure. The procedure is what it is. That was a change to the statute. Now, if we're talking again substantive rights, something else that's not procedural, it may not impact your community depending on whether or not you have that Kaufman language. So it's a complicated, tricky topic. Most recently, there's been changes to Chapter 720, Florida statutes, HOAs, and I'm sure you guys heard about it in the last couple of years, where there's certain provisions now in the statute that says you can't enforce certain covenants that you might have involving the parking of trucks, involving, fining for garbage cans being left out. All of these things that somehow, I guess the legislature is convinced that HOAs are being too mean to their owners. Not entirely sure, but that owners should be able to park their trucks if even if they're work trucks, that sort of thing, commercial vehicles, all of that. So that's been a hot button topic, but that was a change to the statute. And there's an argument that if your HOA, if your association subject to 720 had a provision already in the declaration that said no trucks, no work trucks can be parked in driveways or kept, out overnight. If you already had that provision in there and you did not have Kaufman language, that change to the statute that now says you can't enforce a restriction saying you can't park, commercial vehicles, you can't park work trucks. Now the argument is that provision of the statute doesn't apply to you, and you can still enforce your governing documents. You can still enforce the provision in the declaration. So again, it's a complicated conversation. Talk to your attorneys about it, because it may decide whether or not you want to put Kaufman language in or not. And maybe you want to put some Kaufman language into just sections of your declaration. Maybe you would want any foreclosure assessment recovery to be subject to Florida statutes so that maybe you can recover the most, available to you after a foreclosure.
And this is a good reminder, because I don't think either one of us mentioned this, and I usually do. Anything you hear today, educational in nature only. Emily just mentioned,
Yes.
talk to your association counsel. I've answered a couple of questions, talk to your association counsel. This is educational in nature only. If you have any questions at all, always contact your association counsel. What we are here for today is not legal advice, nor should it be considered as legal advice.
Right. I think I said that in the beginning. But anyway,
You might
so
have.
next one that you get sort of tripped up, because it is, again, we're worried about discrimination. We're worried about claims that are going to cost you guys money. You may sort of stumble into a discrimination claim without realizing that you're doing it, without trying to obviously discriminate against anybody. Just if you have bad language in your governing documents, someone may make a claim against the association. So our community can force rules prohibiting minors from using any of the recreational facilities without an adult present. So again, there's federal fair housing laws to consider. Those prohibit discrimination. One of the protected classes is familial status. So that is essentially families with children. So in addition to age discrimination, racial discrimination, all of these other things, families with children is another protected class. You have to be very careful when you're talking about rules involving minors and children, because again, you don't want it to come off that you're essentially discriminating against families with children. So any rules that involve minors, any rules that you have, or anything in your declaration that talks about anyone who's under 18, that says anything about children, even, they just use that word a lot. You want to look at it. You want to look at it with a fine-tooth comb and really talk to your attorneys. If you are a community that has, housing for older person status, and you're a 55 and over, that's a little different, because you guys are in sort of your own little category. Then there are certain rules that you can adopt about keeping those who are under 18 from doing certain things. And you want to make sure, again, that the rules are reasonable. That's another part of it, Do you want to keep, minors from hanging out in the pool area because you think children are rowdy and gonna, they're gonna splash and they're gonna yell? Well, I know adults that do that too. So that might not be the best reason. If it's for safety reasons, that's different. Because if you had a bunch of 18-year-olds who are great swimmers or 17-year-olds that are great swimmers, that's different than talking about a group of, 6-year-olds maybe. And again, lots of different factors. You can start training, I think, to be a junior lifeguard at like 13, 14 now. I think, what is it? Red Cross starts training them at like 13, 14. So again, what's your real goal? What are you trying to achieve? Is it just to kind of minimize, again, noise and chaos at the pool? That's not necessarily just based on an age thing. So really try and figure out what the behavior is that you're trying to restrict and
Junior
work.
lifeguards can start between
Yeah.
8 and 11.
Yeah. So again, if it's not really a safety issue, if you're worried just about noise and kind of people being rowdy, again, adults can be loud and rowdy too. So it really might not have anything to do with age. And you want to make sure whatever your rules are, whatever your policies are, you're not going to be subject to a discrimination claim. Another one that comes up a lot, and this is something you definitely want to look at in your governing documents that you might want to change, and probably more so in condo world than HOA world, but potentially it could be an HOA issue. The board must obtain a vote of the owners before making any material alterations, true or false? Well, it depends. Depends on your governing documents. In the world of HOAs, material alterations aren't really addressed as much. Typically, there might be language in there like the board can't spend over 10% of the total budget without approval of the members, or, cannot improve the community and spend more than $10,000 without a vote of the owners. That's usually the language in an HOA setting. But again, that might be something you want to change. That could be very outdated. You could have something where it says the board can't spend more than $5,000 on an improvement without a membership vote. And again, if you're one of those communities where it's hard to get a membership vote, spending $5,000, I mean, that's almost a joke. You could spend $5,000 in 2 seconds. So maybe you want to raise that threshold to a higher number or a higher amount, or just give the board complete authority and discretion to improve the community and not require a membership vote. For condos, it's a little different. 718 actually addresses material alterations. It says that if you don't have something already in your declaration, you're going to need a 75% vote of your owners. That is, again, a high threshold. But the disclaimer is if you don't have language to the contrary in your declaration, so you could amend your declaration, or your declaration may have different language. There's also an exception if we're talking about necessary maintenance. A material alteration that, indicates, hey, we're going to paint the building. That's different than, because we want to change the color. We did not, that's different than, hey, we're changing the roof because the roof tile is no longer manufactured and we need to replace the roof. And now we have to use a different material. That might be a necessary maintenance issue where you wouldn't need a membership vote because we can't replace it with exactly what we had. And the board has a duty to do this maintenance. Now, we warn you, don't use that necessary maintenance exception freely. Make sure you have the approval or recommendations and reports from your experts. You need your roof expert or your engineer or whoever it is to confirm this roof needs to be replaced. We cannot use the same substance because it's no longer made or manufactured. So we have to change it to this new material. And if that's the case, now we're talking it's necessary maintenance. You don't need a vote of the owners, even if your documents would otherwise require it. But again, that's something that's an easy fix in your governing documents. If your governing documents default to the statute, if they require a 75% vote, maybe, again, you want to reduce that. Maybe you want a majority of your community to have to sign off on some sort of material alteration as opposed to 75%. All right. All right, another kind of a popular one, so to speak. Delinquent assessments accrue interest at the rate of 18% and $25 late fee applies. Okay, now this is pretty much the same in all of the relevant statutes for co-ops, condos, HOAs, 718, 719, 720. The authority is going to have to be in your governing documents. you have to charge a late fee, it needs to be in your governing documents. And then interest is going to be at the rate reflected in your governing documents. So you want to look at your governing documents and make sure, again, you're not leaving money on the table, that you can charge the highest possible late fees, that you can charge the highest possible interest rate. If there's nothing in the declaration about interest, the rate, you can charge it at 18%. But we want to make sure, again, that you're getting as much as you can. So make sure your governing documents don't limit you. Oftentimes, old language will say interest accrues at 9% or a late fee of $10. So you want to make sure your language is at the highest rate allowable by law, so you can really penalize those late people. A pipe in a wall serving one unit is a maintenance responsibility of that unit owner. Obviously, this is more of a condo related question, but again, that's going to depend completely on the language in your governing documents. That's pipes. We get questions about pipes and leaks all the time. And the question is always, well, is it an association pipe? Is it an owner pipe, but it's in their unit? So is it, or is it in the common elements, but it also services just their unit, whatever it may be. All of those factors just come into play just how it's lined up in your governing documents. So if you have language that you've had to pay for all these repairs, the association's taken on all these repairs, and we'd like the owners to maybe be responsible for certain things, maybe you want to change your maintenance requirements, look at your governing documents, and that would be something that would be, amendable. You can amend that provision, you can change that, you can essentially say, hey, the owner is responsible for this repair now, or the association is going to do it, but we're going to charge the owners back for it because it only services their unit or whatever it may be. So that's another one. It's going to depend highly on what's in your governing documents, and you want to make sure your governing documents sync up to what you want to be responsible for. All right, so here's our little summary page here. A couple little cheat codes to remember. Safe harbor, mortgagee liability. You might be losing money because if you have old language in your governing documents, that's going to control. You might want to amend that, easy amendment to get, the maximum recovery. That ties into interest and late fees, same thing. Make sure your governing documents aren't limiting you. Architectural guidelines, those need to be addressed and reviewed, and make sure you're accounting for the Florida-friendly landscaping, the solar panels, all of those other things. You really have to look at the interplay with your governing documents and what's in the statute, and whether or not you want to defer to the statute all the time or what's in your governing documents sometimes. Right of first refusal, that's different than rights of approval. That's what I was saying. The screening, the reviewing leases and sales and all of that, that's language that you have to look at very, very carefully. And again, big possible exposure to liability if you're not doing it correctly. Old language in documents, that exposes you to possible discrimination claims. That's another thing when we're talking liability issues and possible money that it's going to cost you. You want to make sure your governing documents aren't just basically a sitting liability. Last thing, I know this was a sort of a random slide we included, but I wanted to mention this because it's important for you guys when we're talking about the amendment process in general. If you're going to tell me, and I know, again, it's the question we get all the time, we don't have owners that are involved, we can't get the involvement, we can't get amendments to pass, I'm going to reiterate what I started with, which is first things first, look at your amendment threshold. Just amend that if you can first. Get that down to an attainable number. It is going to be hard. If you have a 75% requirement, getting it down to a majority, you still need that 75% just for that first amendment. But that's going to help you if you can do it. And you really need to convince your owners, we need these amendments. Here's what we can do. We can save money. We can protect ourselves. All of these things. Get that, use that as sort of your sales pitch. Another thing that can help you here, another tool to get owners involved, because we know our owners sometimes are not paying attention, or they don't like to come to meetings, or they don't like to read mail, and they don't like to fill out paperwork because we're also, in our computers nowadays. Electronic voting. Electronic voting is an option for you guys. It's an option for everybody. Condos, HOAs, co-ops. You adopt a resolution, you set it up, you find some vendors. There's a lot of them now. They're not that expensive anymore because there's a little more competition, but you can get electronic voting going in your community. And we've seen that does get the interest up. That does get the participation up. So that's something to consider too. That's another tip we give you when someone says, hey, our community doesn't show up. They don't do anything. I don't think we're going to be able to get them involved. If they can vote online, if they can vote through a, portal, that might get them to get involved. And then they don't have to come to a meeting. They don't have to fill out any paperwork. They don't have to drop off any paperwork. They don't have to mail an envelope. It might make your life a little bit easier. It might get you that participation. So that was sort of our last little tip here. All right, Jeff.
Yeah, and I'm gonna piggyback. Well done, by the way. I know it's a lot of talking, so well done, Emily. Just want to piggyback one quick note about the electronic voting aspect. As the firm's resident nerd and computer nerd, anybody can make a website these days. Get a GoDaddy account. You can make your own website. They have all kinds of cool tools like polling tools and survey tools and things of that sort. So you might be tempted to try to do this electronic voting stuff on your own. Please don't mistake this for a sales pitch. This is not a sales pitch. We do not provide this. Okay.
Right.
But what I want to say is there are a lot of vendors out there that do. Always stick with vendors like that rather than trying to do this yourself because of
There
the
are requirements.
privacy issues that are in the law. And if you notice, those of you with smartphones, and who doesn't have a smartphone these days, whether it's Google or an Android or any alternative, every day you wake up and there's some kind of update that needs to be made. So that's just one example of many of why you should not be trying to do these things yourself because things can change in the operating system that can compromise the privacy aspects. So these companies that specialize this and do nothing but that are on top of that stuff all the time, so you don't have to be.
Right.
Did that make sense?
And you do have to follow when you actually, put this into place. You're required to make sure the system does comply with certain requirements, that it can keep the votes private, especially if we're talking, elections and things like that. Those votes have to be anonymous. So the system needs to be able to track that, Mr. Jones is the owner of Unit 101 and Mr. Jones voted and Unit 101 voted, but we
Right,
don't know that Mr. Jones voted for Bill and Mary
right,
and Steve,
right,
those types of things. And you
right.
guys at home, I mean, if you can figure that out on your own, that's great. I'm
Right.
impressed with technology, but don't try it. Use
Don't
one of these
try it.
platforms because you need to make sure the system complies with all of these very strict requirements.
Absolutely.
But that's the easiest way from what we've seen to get that participation, to get your owners involved. Somewhat,
Absolutely.
one of the questions here is, is there a requirement to mail the documents to the owners or can they be available online? That's all sort of part of this too. You can have owners that opt in to get electronic notices, to get email notices, and then you wouldn't be required to mail them everything. You can email them, but those owners have to opt in. They have to be doing that too. If they don't opt in, you're still doing old-fashioned mailing. So keep that in mind too.
Right. And you can use those informal polling tools for informal polls. Like
Sure.
those you can do on your own. Like, hey, do you think we need more chairs at the pool? Like just to get a consensus of the community. Stuff like that is okay, but again, don't do the
And we'll do it, we tell clients to do that all the time with the polls when we're talking about doing these more substantive amendments. Because again, we don't want you spinning your wheels, wasting time if you're not going to get the support. Maybe the board thinks that, limiting the number of pets in the community to just one dog is a great idea because we have all these complaints about
right.
people not cleaning up after their dogs, and maybe just let everyone have one dog and that'd be great. But then you send a poll out and the owners say, absolutely not. You can't. I want two dogs. Don't limit me to one dog. And you know that then what if we propose that as an amendment, it's not going to fly. It's not going to pass. Now we
It's
saved ourselves some time.
it's what Mr. Spock said before he died in Star Trek II: The Wrath of Khan. The needs of the many outweigh the needs of the few or the one. And
Yeah.
that is community association living in a nutshell right there.
Mm-hmm.
You know, so Emily's going to go through a few of the questions. We had almost 400 of you here today, so we're not going to get to most of them. We're going to get to a few. Before she does that, I just want to mention in the chat area, which you should have pressed by now, we've placed the link for the evaluation in there a few times. So go ahead and click on that, fill out the evaluation, hit submit. And after you hit submit, this I want to show you before Emily takes a few questions. After you hit submit, this is what the evaluation looks like. Okay, you go ahead and fill it in, hit submit. The screen after that has several pieces of information. Bullet point number 2, this one here, has the click here to download and save the slides. That's what many of you were asking about. You hover over the word here, and then your slides are there and you can download them or save them. Okay, and then we have our upcoming webinars here. below that, and they're all complimentary, client or not, just like this one. Okay. And the last thing I want to mention, I see there were about 7 or 8 people here that phoned in, so probably did not see anything today, but heard everything, which is it's okay. We'd rather you see it, but if you can't, you can't. You're not going to see that evaluation link, obviously. So what you're going to do is you're going to go to KBR, that's Kilo Bravo Richard, kbrlegal.com. And at the very top of any page on the website is a button that says Course Certificate Inquiry. Just fill out that information. It comes to me and my colleagues, and we'll make sure you get your certificates if you phoned in. Emily, let's get to a few of the questions.
All right. So I'm trying to answer a couple of these as we go. So someone did say, how do we get that number? How do we get the participation? I told you that's like the number one question we get from this seminar, but
Yeah.
there's only so much of, I can't help you guys. You have to, like I said, first thing, lower that threshold if you can. And you have to maybe have a couple town halls, send out a couple surveys, let owners know, here's what we want to do for you guys. Here's how we think we're going to be able to, increase our revenues and protect ourselves from claims and all of this. We want to do these amendments, but we need to get that amendment threshold down. But you're going to have to get the participation, and it just may require kind of, pounding the pavement, having town halls, holding Zooms, getting the owners, sending out mailings, getting your owners involved. But it is hard. I know that's the biggest question we get. Someone asked about the written approval process and if those written consents are only good for 90 days. The written consent process is very similar to, it kind of mirrors the limited proxy issue in that, yes, so proxies are good for 90 days from the date of the meeting for which they were given, then they expire after 90 days. So if the meeting is going to be held on March 1st, you have 90 days from March 1st to basically use those proxies. Those proxies are still good. Written consent is similar in that there's also a 90-day window, but it's a little different because you're not having a meeting. The clock starts running from the earliest dated written consent form. So if somebody signs their written consent form and gives it back to you, immediately, you send out the mailing today and they give you back the written consent form tomorrow, then your window starts running from February 28th and you get 90 days to gather more written consent forms, You don't have to tell people that they have 90 days to get them to you. You should tell everyone to get them back to you maybe in 30 days. And then you can sort of assess and do another mailing, do another blast, tell people that you still need the written consents. Someone also asked again about the electronic voting. Do that through does that help? Is that in place of having a meeting? Again, the electronic voting is to help you with the voting, but you would do it where you're still scheduling the meeting. They can just vote online so they don't have to show up, essentially.
Right.
All right.
I've got one while you're looking. Somebody asked, is it possible to clearly, and comes back to the educational requirements confusion that we touched upon at the beginning, is it possible to clearly designate these sessions if they are for new board member certifications or for continuing education? Folks, please be sure whether it's our classes, we want you to keep coming back to ours, of course. We think we're the best at it, and we are, or any other class for that matter in this industry. Read more than just the course description. At the very top of our registration portal, it says CEU available for CAMs and for HOA board members. So we clearly state that on every one of our sessions. So just be sure to read all the fine print, read all the requirements, read about how early you have to be here, how long you have to stay, read all that stuff. We don't want you spending 45 minutes here coming into a class 15 minutes late, stay on for the next 45 minutes, and then you're not going to get credit because you missed the first quarter of the class. So read all of the information on any registration portal for any class. Emily, back to you.
Yeah. Someone asked again, what about a third party buying at a foreclosure? Do they owe nothing? Question mark. Again, that's another one where it's going to depend. If your governing documents say essentially sort of have a blanket provision of anyone who buys at the sale of a lender foreclosure or a first mortgage foreclosure owes nothing, then yeah, third party is going to owe nothing. They're going to tell you they owe nothing. They only owe you going forward. Now, the statute does not give them that privilege. That would be something that your governing documents would have to say. And again, that would be something you'd want to change and amend immediately because that's a very easy fix. All right. Let's see. And then someone also again asked about safe harbor. Is it 1 year of assessments, regular and special? So it's the 1% of the mortgage, the lesser of 1% of the mortgage, or 12 months of assessments. So 12, it's usually the 1% of the mortgage, but 12 months of assessments does include everything. Because someone says, is that regular and special assessments? Yes. But again, your regular and your special assessments, 12 months of all of that. But your special assessments, that's another consideration when you're adopting your specials that you want to talk to your counsel about. Because if your special assessment is adopted in such a way that it's due on January 1st, but we're letting people pay over time, that's very different than, one portion is due on January 1st. One segment is due on February 1st. Last payment is due on March 1st, or whatever it is. Very different wording, and that could come into play if you have one of those bigger special assessments. There might be a reason to make it actually have multiple deadlines and due dates, as opposed to making it due in one fell swoop, but then telling people they can pay over time. There could be a logistical difference there. But talk
Emily,
to your attorneys. Yeah.
do 2 or 3 more questions because our advertised time is 3 minutes away.
Okay.
And then I'll remain on to help everybody with the evaluation, questions about how you get your certificates, all that stuff. But go ahead.
So someone said, is it possible to see who opted for or against an issue? Again, for an election, the ballots typically are anonymous. You're not going to know who voted for what. But that's only for an election. For votes on amendments and things like that, proxies, you can they would be part of the official records. You would be able to see them. You'd be able to see how your neighbors voted, in favor of an amendment or not in favor of an amendment. Let's see. Someone's asking about nuisance issues. That's something else that maybe if you have a problem with someone in the community and they are a nuisance, that's another amendment you want to look at. Maybe you want to strengthen that nuisance language in your declaration and put some extra language in there that allows the board to sort of determine what is going to be a nuisance in their own discretion, so that it doesn't make it so hard to pursue a violation if you have a problem owner, we'll say. All right.
So folks, yeah, that's a lot of info.
Things.
And folks, get into the habit too that the chat and the Q&A areas are 2 different modules, and I've put in the chat numerous times that all course related questions should go into the Q&A, not the chat. So please remember that for next time. We don't monitor the chat for class related informational questions. Can I ask you one more question, Emily, before you go?
Sure.
Because this came up 9 different times. Can you prohibit children? I'm just going to say, can you prohibit people in diapers from entering the pool? Children,
because I'm simultaneously typing back to this person.
Are you? Okay.
So it's funny that's the one that stuck out to you. So,
but let's not go with children. Let's people, because I ran a 55 and over. Yeah, I ran a 50.
If you say, can we keep children from getting in the pool with their diaper? Hey guys, we don't want adults in diapers either. We don't want diapers in the pool.
Right.
You don't have to say children. We just don't want diapers in the pool.
Right.
There you go.
Curly, Amir, thank you all for the kind words. Emily, I know you have another appointment to get to. I've kept you here a little bit longer than you wanted.
Thank you guys. Appreciate it. All right, I'll leave you to the fun details now. All right.
Take care. Great seeing you as always.